Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. The code IBC 2016 has evolved in our country suitably to ensure that all the dimensions are taken care of while justice is delivered to all the concerned stakeholders. Therefore, it becomes imperative for all of us to understand that all the gray areas are being clarified by the honorable courts of our country gradually. So, friends, I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements under the Act IBC 2016 and to navigate through the intricacies of its proceedings. So, friends, let us today discuss one landmark case. So, this is the case of Gujarat State Road Development Corporation versus Avil M RP, which was decided on the 9th of October 2024 by the Honorable NCLT Mumbai bench. So, whether a disputed claim is included in the definition of claim under Section 3, subsection 6 of the IBC Code 2016, whether the duty cast upon the IRP or the RP is confined to the administrative function of the collection of claims but to verify the claims, whether a debt not capable of verification by the IRP or the RP based on the documents can be admitted. As per the CRP regulations, resolution professional is duty bound to verify the claims submitted based on the proofs, if any, submitted in accordance with Regulation 7 of the CIRP regulations. At the same time, the IRP or the RP cannot adjudicate a claim in the process of verification. Further, admission of every claim, just because it falls within the wide definition of claim, would seriously prejudice the entire CIRP process. Now, let us see the factual background of this case. The applicant was authorized by the government of Gujarat to augment the existing road on the Bhuj-Bachao section of the state highway in the state of Gujarat by constructing it on build, operate, and transfer basis. In 2009, the consortium comprising Walecha Engineering Limited and PBA Infrastructure Limited as its lead member was selected for this work. The consortium promoted and incorporated Walecha Kutch Toll Roads Limited, which is the corporate debtor, as a limited liability company under the Companies Act 1956 as the entity which shall undertake and perform and exercise the rights of the consortium under the LOA, including the obligation to enter into the concession agreement pursuant to the LOA for executing the road project. The corporate debtor breached both the agreements as it failed to complete the work in time. Thereafter, the applicant provided a one-time infusion of funds of Rs 74 crores to complete the road project on the execution of a tripartite agreement dated 24th of October 2017. However, despite the infusion of funds by the applicant, the CD failed to complete the work. The applicant raised the demand from the CD as per the concession agreement while letter dated 4th of December 2021. However, the applicant did not receive any payment towards the realizable fee despite the issuance of several reminders. Due to the gross delays and non-compliances of the project agreements, the applicant, while letter dated 11th of April 2022, informed the CD that the balance works will be undertaken by the applicant at the sole risk and cost of the corporate debtor. The applicant, by letter dated 25th of July 2022, demanded its rightful dues amounting to Rs 416.27 crores arising from the breaches on the part of the CD. The CD disputed the claim and the matter was referred for conciliation as per the concession agreement. Meanwhile, the CD filed an application under Section 9 of the Arbitration and Conciliation Act 1996, seeking directions to the applicant not to issue any termination till the adjudication of arbitration proceedings. The application was dismissed and no interim relief was granted. Subsequently, the applicant terminated the concession agreement by issuing the termination notice dated 23rd of February 2023. The CD objected to the notice wide letter dated 24th of February 2023. Further, the applicant issued the notice invoking arbitration dated 7th of March 2023, nominating an arbitrator for adjudication. The CD further wide letter dated 19th of March 2023 denied the request of the applicant to nominate its arbitrator since the conciliation proceedings were ongoing and a final order under Section 9 was awaited. The applicant filed an arbitration petition under Section 11 of the ANC Act 1996 before the Honorable High Court of Gujarat, seeking for appointment of the nominee arbitrator of the corporate debtor. Subsequently, the NCLT Mumbai, wide order dated 9th of October 2023, admitted the CD into CIRP and an IRP was appointed. On 30th of November 2023, the IRP filed his reply before the Honorable High Court in Section 11 proceedings, stating that the CD is aggrieved by the alleged unlawful termination of project agreements and the unjustified claims raised against it, and claimed to have incurred losses amounting to rupees 2,000 crore, while also nominating its nominee arbitrator on behalf of the CD. On 8th of December 2023, the applicant filed its claim along with proof of claim for rupees 95.39 crores under Form C as a financial creditor in respect of the one-time infusion of funds made by the applicant under the tripartite agreement, out of which rupees 91.81 crore was admitted by the IRP, further communicating that the remaining principal amount of rupees 47.21 lakhs will be considered in the OC claim. The applicant filed another claim in Form B as an OC for rupees 512.75 crores, which was rejected since the matter was sub judice before the Honorable High Court. Thus, this application under Section 60, subsection 5C of the IBC, read with Rule 11 by the Gujarat State Road Development Corporation against the decision of the RP, rejecting the claim of applicant under Form B as operational creditor of the corporate debtor. Now, what were the issues before the Honorable Court and their decisions? Now, the first was, is the disputed claim included in the definition of claim under Section 3, subsection 6 of the IBC Code 2016? Now, the definition of claim in Section 3, subsection 6 of the IBC Code categorically states that it includes a right to payment, whether or not such a right is reduced to judgment. In Pioneer Urban Land case, the Honorable Supreme Court observed that a claim is defined to mean a right to payment or a right to remedy for breach of contract, whether or not such a right is reduced to judgment. What is clear, therefore, is that a debt is a liability or obligation in respect of a right to payment, even if it arises out of breach of contract, which is due from any person, notwithstanding that there is no adjudication of the said breach followed by a judgment or a decree or order. While it is settled that the claim as defined in the code includes a disputed right to payment, it is necessary to examine the procedure to be followed by the IRP or the RP for admission of the claim. Regulations 7, 8, 8A, 9, and 9A of the CIRP regulations specify filing of the relevant forms. Now, the second is the duty cast upon the IRP or the RP is not confined to the administrative function of the collection of claims, but to verify the claims. A conjoint reading of this sections 18 to 25 and regulation 13 of the CIRP regulations makes it clear that the duty cast upon the IRP or the RP, as the case may be, is not confined to the administrative function of the collection of claims, but to verify the claims submitted by the creditors. Further, Regulation 10 provides that the IRP or the RP, as the case may be, may call for such other evidence or clarification as he deems fit from a creditor for substantiating the whole or part of its claim. Now, the third issue being a debt not capable of verification by IRP or the RP based on the documents cannot be admitted. Now, the creditors or the claimants are bound to submit proof that establishes a debt which can be verified by the IRP based on the documents submitted by the claimant. The nature of the documents specified in the CIRP Regulation 7 is such that claimants can substantiate their claim and the IRP or the IRP can verify the claim without a need for adjudication. It is a settled position of law that the IRP or the RP cannot adjudicate the claim. Therefore, a debt not capable of verification by the IRP or the RP based on the documents cannot be admitted. Admission of every claim just because it falls within the wide definition of claim would seriously prejudice the entire CIRP process. The next issue being, does a concession granted by the applicant fall within the definition of operational debt? For granting the concession, the applicant was entitled to receive various concessional fees and premium in terms of the concession agreement. Thus, the alleged claim arises from the concession granted by the applicant, without which the stated operations would not have been possible. Therefore, the concession granted by the applicant is in the nature of service to the corporate debtor and falls within the definition of operational claims. Fifth is the treatment of claims and counterclaims under the resolution plan. Now, the treatment of the claims and the counterclaims under the resolution plan falls within the domain of commercial wisdom of the COC. And at this stage, therefore, the tribunal refrained from making any observation with regard to the treatment of claims and counterclaims that require adjudication by the appropriate authority or forum. Then the next issue being admission of subsequent claim or modification of claim cannot have the effect of rerunning the CIRP de novo. Now, it is also a settled position of law that admission of subsequent claims or modification of claim admitted by the RP cannot have the effect of rerunning the CIRP de novo. If such a request is allowed, no CIRP would be completed within the time frame envisaged in the code, which is one of the salient features and objectives of the code. Hence, there is no merit in the submission for revision of the information memorandum or for giving directions to revise the resolution plans already submitted by the PRAs, except for considering the interests of the applicant in case some part of the claim is verified or admitted at this stage. Further, as per Regulation 13 of the CIRP regulations, the RP has to put up the additional or subsequently verified claims before the COC for considering such claims in the resolution plan. So, friends, we conclude that the Honorable Tribunal directed the RP to consider that part of the claim submitted by the applicant, which can be verified on the basis of documents submitted by the applicant along with the claims and the Form V. And the other part, which is not capable of verification and substantiation based on the documents, can be treated otherwise on notional basis. And the rest of the prayers made in the application were declined. Therefore, we summarize the clarifications given by the Honorable Court to include that as per the CIRP regulations, RP is duty-bound to verify the claim submitted by the applicant based on the proof, if any, submitted in accordance with Regulation 7 of the CIRP regulations. At the same time, the RP cannot adjudicate a claim in the process of verification. Further, admission of every claim just because it falls within the wide definition of claim would seriously prejudice the entire CIRP process. So, friends, we see that the entire process related to the claims and the verification and the substantiation part of the claims has been aptly clarified by the Honorable Court. So, friends, I trust that you find this both interesting as well as enlightening. So, for further insights into such judicial pronouncements under the Act IBC 2016, please like this video and subscribe to my YouTube channel. So, thank you, friends, for being here with me today. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.